This is the fourth seminar that we've held on cross-examination in international arbitration. The others were in Paris, Vienna, and New York. This seminar will be structured to proceed from the general to the particular, from explanation of the fundamentals of cross-examination to discussion of problems and challenges in conducting cross-examination in international arbitration, to demonstrations of cross-examination, and in a mock arbitration proceeding that will take place this afternoon. This morning's session will continue until 1 o'clock with a 20-30 minute break in the morning. And following me will be remarks from Stefano Azzali, who is the Secretary General of the Milan Chamber of Commerce, to welcome you here to Italy and to Venice. There will then be an introduction to cross-examination by Ben Shepherd, in which he'll discuss the basic concepts of cross-examination and its techniques. They will then be followed by two panel discussions. The first panel will discuss ways in which cross-examination is used effectively in international arbitration, and the second will discuss particular issues such as preparing for cross, redirect, and dealing with foreign languages. Feel free to ask questions when you, if you have any questions. We want you to be participating. The group is of a size where that would permit it. This afternoon, there's a factual scenario that will be used as a basis for the cross-examination. The cross-examination this afternoon will not be rehearsed. It will involve two cross-examinations of the same witness. The second cross-examiner will not have had the benefit of what the first cross-examiners asked, and we'll then have comments about the techniques used in that cross-examination. If you have not already had a look at and had a chance to consider yourselves what you would do in that situation, under those facts as set forth in the scenario, I suggest that in a break or over lunch hour, you take a few minutes to familiarize yourself. I think you'll appreciate the challenges that these cross-examiners will have in cross-examining this witness. We are, as you can see, very electronically up to date here. We have recording, both video and audio, and behind me, of course, is a screen. So if you ask questions, you can probably be on TV. So we'll start now with Stefano Azzali, the Director General of the Milan Chamber of Commerce.
Thank you, Larry. Thanks, Larry. Thanks to Ben, and of course, thanks to Juris and to Michael Kitson, that is the organizer of this event. I wish to welcome you all on behalf of the Milan Chamber of Arbitration, that is one of the supporting organizations of today's event. My role here today is to listen, to learn. So my role is simply to thanks the organizers, thanks to the sponsors, the supporters, and to you all that attended the meeting. We accepted the offer to support the meeting. We were very happy to do it because for many reasons. The Milan Chamber of Arbitration is a special agency of the Milan Chamber of Commerce. We started our activity in 1988, and we do arbitration, we do mediation, and we are very active also in promotion of arbitration. And that's why we are very happy to have supported an event that aims to promote best practices. One of the best practice that we are here today is cross-examination. Italy is more and more used also for international proceedings. We see an increasing number of proceedings where the seat of arbitration is in Italy. That was not the case 20 years ago. Italy is not never been considered an arbitration very friendly country. Something is changing, I believe. The attitude of our judges, the practitioners, also because I would like to say, also because of the Milan Chamber activity in promoting, let's say, in two ways, inbound and outbound. Inbound, importing best practices. Today's event is one example. And exporting also the best practice we have in Italy. We also have very good practitioners, and I believe that is also necessary to export our best practices abroad. So the Milan Chamber of Arbitration was very happy to accept the invitation to support the event for this reason. Another reason is because the subject matter of today's work, cross-examination. In the cases we see in Milano, cross-examination is more and more used. And we see that civil law lawyers sometimes are not so familiar. So we need to know more, we need to learn. When I say we, I don't mean Italians only, I mean civil law lawyers. And I believe that the quality of the faculty today is a guarantee. And we were, again, very happy. Finally, we were very happy because Juris is, I would say, our editor. We published with Juris a commentary of our rules, of the Milan arbitration rules, and so it's a kind of a very, very strong relationship and friendship we have with Juris, and it was, again, another good reason to support the event. We have an office in Rome. We opened up an office in Rome last year, and I'm wondering why we didn't open in Venice. We might do it because it's such a nice place, and I'm very happy that Juris selected, I must say, Venice and not Milano for this event, because the place is really beautiful, the setting is wonderful, and I really hope you all enjoy your staying. And of course, I hope to see you again in Italy. Next time, maybe in Milano. We have an expo, Universal Exposition, starting May 1st. For 6 months, the city of Milano will be invaded apparently by tourists, and we have a very important event for the next 6 months. And then in November, we will have our annual conference, the traditional annual conference that we organize every year. That is, I would say, the only real international event that the Milan Chamber does organize. So I really hope to see you in Milano for one of both, two reasons, the expo and our annual conference. I do apologize if I sit there, but my role is to listen. So once I welcome you all, I will move to dead benches, and really thanks for being here. Thank you.
Thank you, Stefano. We'll now hear from Ben Shepherd, who's the co-editor with me of the cross-examination book and the co-chair of this event today. He will talk about basics and fundamentals of cross-examination.
Well, first, Stefano, thank you for your hospitality. Thank you for the Milan Institute's support, and thanks a million for this fabulous Italian weather. We appreciate it. Stefano mentioned learning arbitration cross-examination techniques is critically important. Like it or not, cross-examination is a standard feature of international arbitration. you need look no further than the IBA rules on the taking of evidence to see that that is the standard practice. It is critically important, and the skills are important. One distinguished arbitrator I heard years ago said that he drafts the award based upon the briefs. He decides who wins the case based upon the cross-examination. It's critically important, and there are great benefits to cross-examination. During cross-examination, you can impeach the credibility of the adverse witness. You can corroborate your own side of the case, develop favorable facts. Those can all be good things that can happen in cross-examination. But lurking behind every cross-examination is the potential for disaster, because you may unwittingly develop evidence that is damaging to your client's case. Why is that? Well, cross-examination, virtually by definition, you're dealing with a hostile adverse witness. That's one. Number two, no matter how well you know the case, the witness knows more than you. They were there. And you can be hurt by what you do not know. So what are the techniques? How do you avoid the potential for damaging your client's case? Well, the ultimate goal is control, tight control of the witness. And I want to offer you today 7 techniques. There's nothing original here. Every American trial lawyer would be familiar with these techniques, but at least to give you a guide on how to control the witness and protect your client's case. All right. First, ask leading questions. Ask leading questions. You use cross-examination to get over your side of the case. Not to ask for more information, but to get off your side of the case. And you do this by short, tight, leading questions, which are really short statements of fact. A leading question actually contains or suggests the answer that you're seeking to get. Now, how do you know you're asking a leading question? Well, there are 2 ways to judge that. Number one, a leading question calls for a yes or no answer. Yes or no. That's all it calls for. Secondly, the flip side, it does not ask for information. If your question is why, how, where, when, that is not a leading question. That's a question that allows the witness to explain the case. Ask leading questions. Now, how do you do that? What are the mechanics? How do you make that work? Well, I think the best thing is to use a variety of techniques. One way is simply state it and with an inflection of the voice. The meeting was in New York. You attended the meeting. The chief executive was at the meeting. Okay, that's one way. Another, and it's often done, is ending the question with correct, true, something like that. Meeting was in New York, correct? Meeting was, you attended the meeting, yes? Chief executive officer attended the meeting, true? Well, okay, that's a good way to do it, variety. The one I find most effective and useful is to use a contraction of the operative verb in your sentence. The meeting was in New York, wasn't it? You attended the meeting, didn't you? Chief executive officer attending the meeting, didn't he or she? It's more conversational, but use a variety of those. But again, use the leading question. You're not asking the witness to explain. You're trying to simply get the answer to your statement of fact. All right, the second technique, critical. Ask only questions to which you already know the answer and can prove you know the answer. I'm talking about on important questions. Professor Irving Younger, late of the Harvard Law School, had formulated his 10 Commandments of Arbitration, and he stated the rationale behind the reason you never ask an important question to which you do not already know the answer, and it's this. If there's an important question And if there is an answer to that question that will hurt your case, that's the answer you're going to get. That's why you should never, again, on an important, critical question, ask an adverse witness why. If you ask that witness why, they'll tell you why. They'll give you a good explanation for their side of the case. Let me give an example from a real case. It's a transcript from an actual case in a Texas court proceeding. Give you an illustration of what can happen to a lawyer who asks an open question to an adverse witness, why? Okay? Here's the question, criminal case. Officer, did you see my client fleeing the scene? Answer, no, sir, but I subsequently observed a person matching the description of the offender running several blocks away. Question, well, officer, who provided this description? He said, answer, well, the officer who responded to the scene. Question, a fellow officer provided the description of this so-called offender. Well, do you trust your fellow officers? Answer, yes, sir, with my life. With your life? Well, let me ask you this question, officer. Do you have a room where you change your clothes in preparation for your daily duties? Well, yes, sir, we do. And do you have a lock on your locker? Yes, sir. Question, now why is it, officer, if you trust your fellow officers with your life, you find it necessary to lock your locker in a room you share with the same officers? Answer, well, you see, sir, we share the building with the court complex, and sometimes lawyers have been known to walk through that building. He should never have asked why. Now, it's not enough to know the answer to the question. You need to be able to prove it. And that means when you're preparing your cross-examination and you are writing out your questions in advance on important issues, you have the document that will provide the correct answer. You ask the question, leading question, you get the wrong answer, you pull into your notebook and you produce the document that will impeach that. If you can't impeach the wrong answer, you probably shouldn't ask the question. Now, this is a generalization. It does not always apply. There are many times when you can ask a question and you don't know the answer. It could be background, it's inconsequential. And there are some cases where the answer itself, yes or no, doesn't really matter to you. But again, the big picture, always ask first leading questions, and number two, ask only those questions to which you know and you can prove you know the answer with the impeaching document. Third technique. Ask simple, clear questions. Avoid verbal clutter like this. Now let me ask you this question. You ever heard that? Now let me ask you this question. Don't ask till ask. Just ask the question. Now let me ask you this question. For the record, would you please tell the members of the tribunal, we're just trying to fix the date of the meeting. The meeting was in New York, wasn't it? Well, that's a lot of wasted breath. How about the meeting was in New York, wasn't it? Avoid the compound question. Compound question would be, all right, isn't it true you attended the meeting? The audit report was reviewed at the meeting. You voted on it, and the minutes were approved, and the answer is no. What's the answer mean? That's an ambiguous answer, isn't it? You don't know if the witness meant, no, I didn't attend the meeting. No, it wasn't in New York. No, we didn't look at the audit report. Break it down question by question. Avoid the disjunctive question. Did you see the metallurgical report, or did you examine the steel? Yes. Which is it? It's confusing. Break it down, simple, clear questions. Okay. Fourth technique, don't ask the witness just to repeat the testimony they've already given. Now, there are occasions where you will need to ask the witness to set the context. In your witness statement, you describe the meeting of such and such as follows. You're setting the context. Sure, you'll need to do that to set it up. Or you may need to set up an impeachment where you've got something you want to use to impeach the witness. You're going to need to set it up. Okay, that's fine as far as it goes. But don't ask the witness simply to rehash everything they've already said or go over their witness statement. That just gives the witness a chance to corroborate their side of the case. And you're trying to use cross-examination to get your side of the case. Okay. Next technique. Don't quarrel with the witness. Don't quarrel with the witness. First place, it's very ineffective. You mean to tell this tribunal? Da, da, da. Well, yes, that's exactly what I'm telling the tribunal. This sarcastic tone, oh, you couldn't possibly mean this. Well, yes, that's exactly what I mean. It's very ineffective. Number two, you know what it tells the tribunal? This must really hurt. They've got this lawyer's attention and they're squealing. And a third downside is you might actually displease the tribunal. That might be the case where the tribunal, in response to an objection, with all due respect, members of the tribunal, the lawyer's badgering the witness. We sustain the objection. That's argumentative. Do you have a question for the witness? Don't argue with the witness. Save argument for argument. Save your argument for closing for your brief. You'll have plenty of time, either by oral closing at the conclusion of the hearing, or very typical, as you know, in international arbitration. You'll have post-hearing briefs at which you'll have an opportunity to recap the testimony, phrase it the way you want it. Save your argument for the closing. In other words, once you've got your good answer from your good, close, tight, leading question that helps your case, move on. Don't keep coming back. I've seen this, I see it too often. And the question often looks like it would be a nice heading in the brief. It's an argument, and they're trying to get the client now to basically agree to the ultimate conclusion. And a really savvy, smart witness will figure this out, and will start to qualify, will start to hedge, will start to undermine the very good answer that you already secured. And when I see that happening, I realize here's the mistake. The lawyer is trying to argue the case now, rather than just let the good answer stand and saving that with a transcript for the brief. So don't argue with a witness and save your argument for the closing. Save the closing. Here's one other technique. I think it's very, very effective. I found it effective when I was counsel, and as an arbitrator, I find good lawyers using it to good effect. And that is, use cross-examination to highlight favorable materials in the documents. Now, the arbitrators, of course, can read. They've seen the documents. And, of course, we all know that the arbitrators have photographic memories and that they have memorized all 15 volumes of the documents that are sitting on the table, and that you can trust them to know everything in the file, right? That's not necessarily the case. The arbitrators could use your help in emphasizing some of the key points, and cross-examination is a good time to do it. Now, here's the way you do this. Here's the way you do it. And it's all about witness control, all right? You've got the document that you want to highlight to the tribunal. The way you do it is you ask the witness, may I please ask you to turn to tab 15 in your witness notebook. That's the meeting minutes of November 15th, 2014. Do you have that, sir? Do you see the second paragraph? Yes, sir, I do. Here's your question. You read the language. Don't ask the witness to read it. You read it. Read it clearly out loud. And here's your question, and your only question. Did I read that correctly? That's all you ask. Did I read that correctly? Well, assuming you can read, the only answer to that question is yes. And you move on to the next topic. It's really heartbreaking to see a lawyer, got the great document, did you ask the question, did I read that correctly, got the answer yes. That's a true statement, isn't it? Well, no, it's not a true statement. The man that wrote that report did not have all the facts, blah, blah, blah. Do you agree with that statement? Well, no, I don't agree with that statement. Why does it state that? Well, because we didn't have all the, see what I'm saying? Get your question, did I read that correctly? Move on. That's your last question. You just move on to the next topic. All of these are, of course, subject to exception, but I think as general guiding principles, what these tactics will enable you to do is control the witness so that the witness is not moving out to damage your case. And I know all of you practice these skills and will do a good job of it, and I can give you, in closing, one further example from another Texas transcript, which I think reflects a pretty good cross-examination. Here's the question. Are you sure this is the man who stole your car last Thursday? Answer, well, I was. Now, after the cross-examination, I'm not sure I ever owned a car. Thank you very much.
Thank you very much, Ben. We're moving along ahead of schedule, so what we'll do is take a few minutes to reorganize ourselves and bring up the first panel to discuss various issues in cross-examination and international arbitration. We'll ask Sophie, Nappert, Mr. Haigh, Santoro, Vasquez, Ruttinger to come up. And I will move over to the place where Ben was.
I know. Goodness me. I should have gone for hair and makeup this morning. Frank. Good morning. Good, thanks. They are like that.
Okay, we are organized. We don't need to go through the backgrounds of these panelists because they're all set out in your materials. But suffice it to say that they're experienced international arbitration practitioners and international